She looked me up and down the way people do when they've already decided who you are. The sun was sharp that afternoon, bouncing off the polished SUVs lined along the curb of the gated community. I had just stepped out of my car, still in my Navy suit, briefcase in hand, reviewing notes for a federal hearing I had scheduled the next morning. I own the house at the end of the cul-de-sac, the brick colonial with the wide porch and the oak tree out front. I worked for it. I earned it. But to her, none of that mattered. She marched across the perfectly trimmed lawn, clipboard tucked under her arm like a badge of authority. Without a greeting, without even asking my name, she tilted her sunglasses down and said, "Excuse me, are you the help? The cleaning service parks in the back." For a moment, the world went silent, not because I hadn't heard her, but because I had. Every syllable was clear. Me, a sitting federal judge, appointed to the bench after 2 decades as a constitutional attorney, being asked if I was the help in my own driveway. I smiled, calm and measured, the same expression I wear in a courtroom when counsel attempts theatrics. "No," I replied evenly, "I live here." She blinked, clearly unprepared for that answer. Her posture stiffened. "Oh," she said, glancing again at her clipboard. "Well, I'm on the HOA board. We've had complaints about unfamiliar vehicles." Her eyes flicked toward my car as if it didn't belong in the neighborhood. I recognized the tone. It wasn't about parking. It wasn't about policy. It was about assumption. I've presided over cases involving discrimination, housing bias, and civil rights violations. I know how subtle prejudice presents itself, dressed up in procedure and policy, hiding behind bylaws and community standards. She began lecturing me about landscaping regulations, trash bin placement, and approved exterior paint shades, never once asking if I was the homeowner. I let her finish. Then I asked her for her full name and position on the HOA board. Her confidence faltered just slightly. The next HOA meeting was scheduled for that Thursday evening in the community clubhouse. I attended, not in my judicial robe, of course, but in a simple gray suit. When I entered, conversations hushed. The same woman, Karen, as she introduced herself to others with forced charm, was leading the discussion. She spoke passionately about maintaining property values and preserving the character of the neighborhood. When it was time for open comments, I stood. I introduced myself by my full name, including the honorific I rarely use outside court. I stated calmly and clearly that I am a United States federal judge serving in our district court. You could hear a pen drop. Faces shifted. Karen's expression drained of color. I didn't raise my voice. I didn't humiliate her. I simply recounted our interaction verbatim and asked whether the HOA board believed selective enforcement and discriminatory assumptions aligned with federal housing law. I explained that while I do not preside over HOA disputes, I am deeply familiar with the Fair Housing Act and other civil rights statutes that prohibit discrimination based on race, color, national origin, and other protected categories. I reminded them that intent is not always required for impact, that bias, even when subtle, can create legal exposure. I saw several board members exchange nervous glances. Karen attempted to interrupt, claiming there must have been a misunderstanding. I reassured her that I understood perfectly. The issue wasn't confusion. The issue was presumption. I told them I chose this neighborhood because I believed it was a community. Communities require respect, not suspicion disguised as governance. In the days that followed, something shifted. Neighbors who had barely nodded at me before suddenly introduced themselves. Some apologized indirectly, saying they were glad to have someone accomplished in the neighborhood. It was fascinating how a title changed the narrative. But here's the truth. I deserved respect before they knew my profession. Every person does. Whether someone is a cleaner, a landscaper, a nanny, or a federal judge, dignity is not hierarchical. I've ruled from the bench on cases involving wrongful termination, unlawful searches, and constitutional violations. None of those decisions required me to shout to command authority. Authority, when legitimate, speaks quietly. That afternoon in my driveway, I didn't need to raise my voice either. Karen eventually sent an email apology, copied to the board. It was carefully worded, referencing miscommunication. I accepted it, but I also requested the HOA undergo fair housing compliance training. To their credit, they agreed. Policies were revised. Complaint procedures were standardized to prevent selective targeting. What started as a humiliating assumption became a catalyst for accountability. I often tell young attorneys that power is most effective when it is controlled. That day, restraint made a stronger statement than anger ever could. The irony is that if I had been the help, her comment would have been just as unacceptable. The measure of a community is not how it treats those with titles, it's how it treats those without them. Even now, when I pull into my driveway beneath that oak tree, I think about how easily prejudice slips into everyday interactions. I also think about the responsibility that comes with my role. I cannot control every assumption someone makes, but I can control how I respond. In court, I enforce the Constitution. At home, I model composure. Karen still avoids direct eye contact, though she is unfailingly polite now. And every HOA meeting includes a reminder about inclusive language and equal enforcement. Sometimes justice doesn't require a gavel. Sometimes it begins with a simple sentence spoken calmly in a driveway. No, I live here.